This is very much a practical talk about assessing compensation, and I've chosen to refer to the case of Dr. Michalak, not because it's one of my cases, although I have to say it was a really good decision. And I'm not saying that from any biased point of view, because quite a lot of our arguments were rejected by the tribunal. Our schedule was for more than £4.5 million. But you may say, well, why talk about an employment tribunal case? Well, it was supposedly the highest award reported in the employment tribunal. There have been many higher settlements, as you'll all know. But what's interesting about Michalak was that it was a case that was fought and in which the tribunal gave a thoroughly analysed, good, clear decision in relation to every head of loss. It is a case that is reported, it's accessible, and I've given the link at the bottom of page 4 of my report. It's a case in which much of the credit... Sorry, I'm reminded I haven't dealt with the technology. It's a case in which really a lot of the credit goes to two people, one of whom was my instructing solicitor, who's actually now the president of ILEX, Nick Hanning, who produced, for the purpose of this case, schedules which were as near perfect as one could imagine in this sort of case, because essentially at the root of this sort of remedy, high-value remedy hearing, is producing a cogent, persuasive, detailed schedule, if you're a claimant, for the tribunal's purposes, and on the other hand, if you're representing a respondent, a detailed counter schedule setting out all of your arguments with detailed calculations. The other person who deserved enormous credit in this case was Dr. Michalak's husband, who represented her at the liability hearing and performed an investigation of the facts and a thorough approach to the evidence, which I suspect any legal representative in this room would be extremely proud of. I've started off just by looking at what are really the broad principles, of course very well established principles, but sometimes we don't go back to them. Ask employment judges if you meet them at social events or conferences. Do people prepare cases properly for remedy? And I suspect you may meet quite frequently a negative answer. Everything is prepared with liability in mind, but remedy isn't always prepared as it should be. General principles. What you're dealing with, of course, is the principle of full compensation, putting the claimant in the position which they would have been in if the act of discrimination had not occurred, so far as possible. Very clear, well-established principles, and I'm going to be focusing in particular on discrimination cases. As matters stand at the moment, I think the most important case when you're starting with general principle is the case of Wardle and Credit Agricole. And I say it's the most important case because for many years we grappled with something that came out of the decision of MOD and Cannock, which was this approach to remedy by reference to percentage chances. So you had tribunals saying, well, there is a 60% chance that the claimant would have continued working for the respondent. If he had, there was a 30% chance that at some point, perhaps in 10 years' time, he might have been made redundant. Or that there would have been a redundancy exercise. And if there'd been a redundancy exercise, there was a 25% chance that he would have been selected. And then, of course, tribunals had to try and work in those percentages to the figures. It was virtually impossible, if not impossible, and wholly unrealistic. Wardle has given us a much simpler way through all of this, which is very similar to the approach taken in personal injury cases, which is that what you do is you look broadly at career models. You look at the career model of the claimant before the act of discrimination, which led to dismissal, that's the assumption, and you look at the career model now. You factor in the chances and you then ask what would probably have happened. So it's actually in practice what in low value cases tribunals have always done. Oh, well, within a year this claimant will get another job. And that's now been introduced effectively into the high value cases through Wardle. Factor in all the chances and then decide what is probable. It's all about presenting a persuasive case. Of course, future losses are always speculative. But the way to deal with this is to produce, if you're acting for a claimant or a respondent, a cogent case supporting your case theory with a sound evidential basis which concentrates on the detail. And I'll just give an example of this which arose in the Michalak case. As you might imagine, acting for the claimant, we suggested that Dr. Michalak was going to work until age 75, but for her dismissal. The trust contended that she was going to work until age 60, but for her dismissal. So that was the parameters of the retiring age issue. How did the tribunal approach it? Well, of course, evidentially, they knew about the removal of the default retirement age. So that was a helpful factor. They then took into account, and it was part of the evidence, the personal circumstances of Dr. Michalak, not least the fact that she had a young child who she'd had in her early to mid-40s, and who was likely still to be dependent as she proceeded into her late 60s. We then, within our schedule, knowing the parameters of the dispute, gave the tribunal a detailed calculation based on retirement at age 68, thinking that that was possibly the upper limit, possibly, of where the tribunal might go, and the tribunal, having been provided with that calculation, adopted it. On the other side, and of course there were very cogent arguments put by Tom Linden, who represented the trust, but in relation to this issue, there was evidence from the trust's medical director. His assertion was, based upon current statistics, gender statistics, that women doctors working in the health service simply didn't work beyond 60. In general, they tended to retire in their 50s. Well, of course, that was all very well, but people retiring in their 50s are people who entered the profession 30 years ago. And it was pointed out to the medical director that actually the numbers of women coming into the profession have, of course, been much higher in recent years, and therefore these statistics were unlikely to be reliable in relation to the date when Dr. Michalak was considering retirement. He stuck to his guns. I say no more. In terms of causes of action, very briefly, I mean, frequently these cases, there are overlapping causes of action. In particular now, whistleblowing and discrimination seem to be brought as cases, concurrent cases causing psychiatric illness. One of the most difficult questions, certainly for claimants' representatives, is, do we bring this claim in the tribunal or do we bring it in the civil court? That in itself could provide another whole paper, but it's very difficult in these high-value personal injury, discrimination-related personal injury claims to get the tactics absolutely right. It is very rare for a personal injury claim to be ready to proceed with the sort of haste that the tribunals like to deal with their cases with within 3 months, which of course is the primary limitation period. And there are also all sorts of other factors in relation to foreseeability and so on that need to be taken into account. I'm not going to dwell on the facts of Dr. Michalak's case, simply to highlight she was an extremely successful doctor. She was a real high flyer. She had come second in her cohort in Poland at medical school and had done so even though she had had her first child while she was still at university. The tribunal found that there was sex and race discrimination. There was medical evidence before the tribunal, and perhaps somewhat unusually, there was also actuarial evidence. And there was actuarial evidence which, because there was an issue as to the appropriate discount rate to be applied in calculating future losses. And to me, it's the tribunal's finding on that, which was probably the most, in a sense, interesting and important outcome of the case in terms of looking at further cases. I've said in my paper that this is an area which practitioners may find difficult. What I really mean by that is that high-value claims in the tribunal are still relatively unusual. And that really has two consequences. One is that employment lawyers are not always as familiar as perhaps they should be with the Ogden tables and the methods of calculating future loss, which personal injury practitioners are very familiar with. But also that tribunals, lay members and employment judges will need very careful guidance through how to calculate the particular heads of loss. I've just flagged up various considerations: foreseeability, chances, double recovery, allowing for contingencies. Injury to feelings, I'm going to skip over. You all know Vento and DeBell. I simply wanted to refer in relation to this to something that Mr. Justice Underhill said in the case of Shaw, which is an aggravated damages case to which I refer in my paper. And that is that he said that compensation for discrimination, and I set this out at paragraph 22 actually, that there's nothing in the statute to suggest that discrimination is to be treated as a specially heinous wrong to which special rules of compensation should apply. Now, I simply flagged that up because I think in relation to injury to feelings, frequently witness statements will address at some length how appallingly badly a particular individual was treated, but will perhaps devote a sentence or two only to the effect of that treatment on the individual. Now, injury to feelings, it is compensatory, and tribunals, in order to make proper awards that stand up in the EAT, have got to have some evidence as to why, as to how this individual was affected, how it may have affected their day-to-day life, how they felt about it, etc. So again, simply flag that up. Personal injury awards. I'm just going to pick up my watch, otherwise I'm going to go on for more than half an hour. And Mark will be glaring at me. Personal injury cases, non-financial losses, the JSB guidelines you'll all be familiar with. They're now known as the Judicial College Guidelines. That's because the Judicial Studies Board is now the Judicial College. And the new guidelines came out in September 2012. That's the 11th edition. Generally, overlap between pain, suffering and loss of amenity, what we sometimes call personal injury damages, and injury to feelings, is allowed for by calculating the two awards, standing back and then looking at whether the total award is proportionate, and that was made clear in the case of HM Prisons and Salmon. Again, just to be slightly wary in these very high value claims, in Michalak, the tribunal was persuaded to make two entirely separate awards with no discount for overlap. They awarded $30,000 for injury to feelings and $56,000 for personal injury, and they did not discount that total figure, so don't assume there'll be a discount in every case. Expert evidence is, of course, a feature of these high-value cases. Medical experts, possibly actuaries, accountants, occasionally employment experts. They're very unpopular in the courts, and I don't think they're terribly popular in the tribunals either. And I've just flagged up, had I moved to my next slide, the importance of experts' joint meetings, so that, so far as possible, where there are issues to be narrowed, that the experts narrow those issues. Loss of congenial employment I've only referred to because MOD and Cannock, it was stated by Mr. Justice Morrison, then President of the EAT, that such an award was unlikely to be made in the tribunal, although they are sometimes made in personal injury cases, because there was an overlap with awards for injury to feelings. Those representing claimants, I think this is worth revisiting in the right case, because I actually think there is a significant difference between injury to feelings on the one hand and loss of congenial employment on the other, which is where somebody may have had a career, perhaps in nursing, firefighting, whatever it is, which they're no longer able to pursue as a result of discrimination and the injury caused thereby. Aggravated damages, I am going to refer to briefly because there is this new case, Commissioner of Police for the Metropolis and Shore, which really shows just a slightly different approach to aggravated damages and how they should be incorporated in any award. President Mr. Justice Underhill, then President, said that aggravated damages should be formulated as a subheading of injury to feelings. I think in the past, generally, tribunals have assessed a separate figure for aggravated damages, so injury to feelings X, aggravated damages Y. And what's being said here is that injury to feelings awards should now incorporate the aggravated damages, so injury to feelings X incorporating aggravated damages Y. And it was made pretty clear in Shaw that certainly Mr. Justice Underhill thought there was some reason, although he didn't depart obviously from Court of Appeal authority, but was quite critical of having aggravated damages at all in discrimination cases. Exemplary damages have always been exceptional. I think I've, in my decades of tribunal experience, had 3 occasions where I've got exemplary damages. Michalak was the third. A sum of £4,000 was awarded for exemplary damages. And that was for a particular reason. It was because her suspension, which should have been limited to 6 months, was extended unlawfully, and the tribunal took a very dim view of that. It was extended to about 2 years, and they took a very dim view of it for 2 reasons. One was that the trust witnesses, or the trust, or a representative of the trust, had been untruthful when informing the advisory body in relation to the suspension. But perhaps more importantly, the tribunal took the view that the 6 months maximum suspension, which came from the national procedure, was there in order to ensure that taxpayers' money was not wasted. That is, that where doctors were held on long periods of suspension, continuing to be paid. And for that reason, they thought exemplary damage was appropriate. I'm now very briefly coming to what I think is the most interesting, really, finding in some ways in the Michalak case, which is this question of the 2.5% discount rate. The discount rate, of course, is there to represent the investment value, really, of damages. So it's assumed that when you get your compensation, if you invest it, I'm simplifying this, but if you invest it, you should get a real rate of return of 2.5%. That is 2.5% above the rate of inflation. Now, I mean, everybody knows that that's pretty difficult to do. There may be some gamblers in the room who achieve that, but the great majority don't. And this has been under question in the civil courts for some time. It's a rate prescribed by the Lord Chancellor under the Damages Act 1996. And it is currently under consultation. There's a consultation that will be completed, or responses to which have to be completed by, I think, the 23rd of October. And it's been thought for many years that the discount rate should go down, and that would have the effect of increasing multipliers and therefore increasing damages for future loss. There is a case in the EAT called Benchmark Dental Laboratories and Perfit, in which it's said that it is good practice for the tribunal to follow the approach in the civil courts, even though the prescribed discount rate of 2.5% doesn't apply to tribunals. And this bold tribunal in Michalak nevertheless used a discount rate of 1%. Now, they did that on the basis of actuarial evidence, expert evidence, to the effect that if Dr. Michalak were compensated with a 2.5% discount rate, she would be significantly undercompensated. And so, on the basis of Michalak, and of course it hasn't been appealed, at the moment there is at least that argument available for parties to run. Who knows whether other tribunals would take the same view. I think my final slides I can get through very quickly. I've referred to the speculative nature of future loss and what are really the key cases. Pension loss, likely to arise in these high-value claims, but the subject for a total new talk. If we had any grievance on the claimant side in Michalak, it was, although we'd produced an extremely detailed calculation, which was not based on the tribunal's own booklet, own guidance, the tribunal nevertheless followed its own guidance, taking the substantial loss approach. In practice, it didn't make much difference. Claims for care, can I just briefly touch on this? Where somebody suffers severe psychiatric illness, as Dr. Michalak did, they may need a great deal of help and support during the period of their illness. In the case of Michalak, we brought a claim and an award was made for around £75,000 in respect of the additional care and assistance that Dr. Michalak needed, primarily given by her husband, but also by her brother or brother-in-law. There was no expert evidence in the case, but the way the tribunal approached it was to make a finding as to the hours of care and assistance that were provided, and then to look at the standard rates used in personal injury proceedings, which are found in a publication which I say anyone doing a high-value case ought to have or have access to, which is the PNBA annual book called Facts and Figures. And just finally, I've just flagged up other elements of claims: fringe benefits, interest. In Michalak, 2 interim payments were made. Tribunals, I don't think, have any power to make interim payments, but in this particular case there was no real dispute, and of course from respondents' perspectives, because of the rates of interest in the tribunal, it may be in their interest to make interim payments.